Good morning, students. Hope I'm audible. Welcome to Ekcel Academy's CSEET crash course. Today we'll be looking at legal aptitude, the last part of legal aptitude. As you are already aware, we at Ekcel Academy conduct classes for CS course, CSEET, executive, and of course the professional as well. Now, so there will be a new batch starting soon. If at all you would like to join the new batch, I would suggest please do sign up on Ekcel Academy's website, the link for which is in the description. You can also see the website URL on the screen, ekcelacademy.com, ekcelacademy.com. So do visit there. You'll get a lot of updates on the CS course, and also lots of notes, mock tests, daily quizzes, etc. All those things are available free of cost, of course, on the website. So do check it out, and also there are lots of sample classes as well. So I would suggest please do check it out. Now, before we proceed further, let us quickly recall what we did yesterday. Yesterday we looked into Constitution. So we looked at the various rights and duties, and we saw what a citizen enjoys and what are the duties of the citizen as well, and also the non-citizens. So we looked at few of the fundamental rights which are also available for those who are not citizens as well. So in fact, most of the fundamental rights are also available for those who are not citizens, as long as they are in India. So they will still get those rights. Now, let's move on to the next topic, which is company law. We already looked at the introduction in the previous week, wherein we saw what is a company and how is that word derived. So we noticed that the company word is derived from a Latin word cum and panis. So cum means together, panis means to have, bread. So they used to have bread together or eat food together, and as a result, the word company came into existence. So that's how the word company came into existence. So we have looked into all this in the previous class itself. Let us move ahead. Even this was covered. I think we had covered up to this point. Yes, corporate personality. So now what exactly is this corporate personality? Let's see. By incorporation under the Act, the company is vested with a corporate personality quite distinct from individuals who are its members. So what they're trying to say is, once you become incorporated under the Companies Act, so you will have a distinct identity from individuals who are its members. That means they might be the members who started the company, but they're all individuals. But you as a company will have a separate entity, separate legal entity, meaning in the sense, the company can do things in its own name. It need not have to depend on the name of the members or those promoters or shareholders who created the company. This is so much unlike partnership, wherein everything is more or less done in the name of partners only, and the partnership doesn't usually have a separate legal entity. So that is what is the main difference here. So it is capable of owning property, so any land, incurring debts, borrowing money. Of course, companies, we know, borrows money in the form of loans. So when they borrow money, the company would be responsible, not the person who was in charge of the company when the company borrowed money. So we have seen many cases wherein the promoters have washed their hands off, and they're laying the blame squarely on the company itself. Case in point, Kingfisher. Having a bank account, a company can also have a bank account. It can employ people, it can enter into contracts and sue and be sued. So all these things are there as part of the separate legal entity concept. Of course, its members are owners, but they can also be creditors simultaneously. See, the point here is, you cannot say, if let's say there is a company, let me just give you an example. Let's say there is a company, let's call it A Limited for our convenience. Now A Limited has only two members, A and B. A has the majority shares, let's say 999 shares, and B has 1 share. Now A is practically the owner of A Limited, even though it's a company. Now, at the same time, A can also be a creditor because the company doesn't treat A as owner technically, and for the company, A can also be a creditor. So, for the company or in the eyes of company, these two are two distinct roles which can be played by the same person because company doesn't treat A as an owner; it only treats him as a shareholder. So that's how separate entity concept works. Uh, anyway, that's one of the ways in which it works actually. Let's see. A shareholder cannot be held liable for the acts of the company, even if he holds virtually the entire share capital. So, meaning, if let's say in the previous case, as we saw, a shareholder was holding 999 shares. In spite of that, we cannot hold that particular person liable, even if the company does something or if the company goes into debt trap or whatever it is. That person will not be held liable because the company, we believe, acted on its own, or rather the company acted in its own capacity. So therefore the shareholders will not be held responsible, so they cannot be bound by the acts of the company. Whereas a partner will be bound by the acts of a partnership firm. The shareholders are not the agents of the company, and so they cannot bind it by their acts. Likewise, shareholders also cannot bind the company by their acts because they are not acting on behalf of the company. There, they are only the owners of the company. So, if the company, unless the company exclusively gives them the right through proper process, they will not be considered as someone who would be representing the company. Hmm. Okay, now let's come to this important case law, that is Solomon versus Solomon Company Limited. So again, happened in 1897, much before we even had Companies Act in India. Once a company has been validly constituted under Companies Act, it becomes a legal person distinct from its members, and for this purpose, it is immaterial whether any member has a large or a small proportion of the shares and whether he holds those shares beneficially or as a mere trustee. So this Solomon case is very similar to this example which I gave earlier. One person, that is Solomon himself, held majority of the shares. Let's see what do they say. Solomon had for some years carried on prosperous business as a leather merchant and boot manufacturer, and his four sons as shareholders. See, he had his four sons as shareholders, that's all, and each of them had only one share, whereas the rest of the shares were absolutely held by Solomon only. Solomon sold his business to the company for the sum of 38,000 pounds. The company's nominal capital was 40,000 in £1 share. In part payment of the purchase money for the business sold to the company, debentures of the amount 10,000 secured by a floating charge on company's assets were issued to Solomon. Okay, so this is interesting. So 40,000 shares were there, and on top of that, 10,000 debenture bonds were issued to Solomon. That too secured. Now, secured means if something happens to the company, if there is a liquidation, then the first payment will be given to the secured creditors. So now Solomon becomes a secured creditor. You may tell he holds virtually the majority shares of the company, yes, but at the same time he is also someone who has lent money to the business in capacity of a secured creditor. So therefore, there are two distinct identities from the point of view of company. Now, so far so good, but what exactly happened? In part payment of the purchase money for business sold to the company, debentures, that is done. No, okay. The company soon ran into difficulties, and the debentures holders appointed a receiver, and the company went into liquidation. So there was some kind of financial problems, and the company went into liquidation. But when the company went into liquidation, the total amounts which the company had was only £6,050, whereas its liabilities were £10,000 secured by debentures, 8,000 owing to unsecured trade creditors. Okay, interesting. Assets were only 6,000, with 6,000 assets, the company had to first fulfill secured creditors, or rather debentures, and some 8,050, I guess, unsecured. Now the problem here is, since the liability is more than the amount of assets which we have, obviously the assets whatever we have will not be sufficient to clear the debt as well as the unsecured creditors. Now which one should we clear first, or should we clear in pro rata basis? That was the problem which the company had. But what the company did was, they made sure that the secured creditors were paid first, and only then, if at all something was left, it was given to the creditors. But again, if you look at it, there will be nothing left, because secured creditors is totaling to 10,000, so there won't be anything left. This was precisely the problem of the other unsecured creditors. What their contention was: how can Solomon pay himself first and then pay others? If you are a company, the owner will get paid at the end, but the others should get paid first. But his contention was, I may be owner, yes, of course, I agree, but at the same time, as a lender, I had lent money to the company, that is 10,000 pounds, which was in fact secured. So this is different from my ownership of shares. That's exactly was his contention. His contention was, you cannot club the two. You cannot club my position as the majority shareholder and also my position as a majority lender. So these two are separate positions with respect to the company. I should be first paid, or rather paid back, the money which I have lent in the form of debentures, because they are secure, and then we'll make the payment to the unsecured creditors, and finally, if anything is left, to the owners. Obviously there wasn't much left. So let's see what exactly the court said. That was his contention. When the memorandum is duly signed and registered, though there be only 7 shares taken, the subscribers are a body corporate. Yes, we have only 7 shares. We know who they are. It's a family, and mostly Mr. Solomon holds the majority shares. Yet, it's a body corporate, meaning it's a corporate with its own separate entity. Okay. So you cannot say the body corporate is owned by someone. No, body corporate will have its own legal entity, or rather identity, and therefore it cannot be considered as having been owned by someone. So therefore the court disregarded the creditor's claim that Solomon himself is the owner. So first it told he should be paid in his capacity as the secured creditor, that is, he lent money in the form of debt. So, and then the unsecured creditors will get the money. That's what the court held. The company is at law a different person altogether from the subscribers to the memorandum. And though it may be that after incorporation the business is precisely the same as before. See, even before he sold the company to the Solomon Limited, he was running the same business. He himself was the major decision maker. So even after the company was created, he still did the same thing. Doesn't really matter. There is nothing in the act requiring that subscribers to the memorandum should be independent or unconnected, or that they have any of them should take a substantial interest in the undertakings, or that they should have a mind or will of their own, or that there will be anything like a balance of power in the constitution of a company. Okay, that was evident, so I won't get into that. Okay, there is one more case, that is Lee versus Lee's Air Farming Limited, wherein company was formed for the purpose of aerial top dressing, mostly for the forms. Lee, a qualified pilot, held all but 1 shares of the company. So if there were 1,000 shares, Lee held 999 shares. What did he do? He was a pilot, by the way. He wanted himself the managing director. So since he was the majority shareholder, he became the managing director. Once becoming the managing director, he appointed himself as the chief pilot. See, he did different things in his different capacity. In his capacity as the majority shareholder, he appointed himself as MD. In his capacity as the MD, he appointed himself once again as the chief pilot. So he is both employee and at the same time a majority shareholder. And unfortunately, he died in air crash while working for the company. So then his widow claimed compensation for the death of her husband in the course of his employment. So she said, since he was working as an employee because he died during air crash, what was he doing? He was being a pilot when he was killed. So if he was a pilot when he was killed, that means he was an employee. So since he was an employee, we should get money under Employee Compensation Act, whatever it is in New Zealand. The company opposed the claim on the ground that Lee was not a worker, as the same person could not be the employer and employee. That condition won't hold good now, because if you look at this, how can Lee be employer as well? Because the company was the employer. Of course, it is Lee's Air Farming Limited, and of course, Lee owns the majority shares, but it's not Lee, that is Mr. Lee, who was the employer. It was the company which appointed him. Okay, of course, he may have appointed himself, but he only was the conduit, and the appointee would be the company. Okay. Appointee, yeah, I think it's the right word, I guess. Anyway, the person who appointed, or the entity which appointed Mr. Lee, was the company itself through Mr. Lee, the MD. So finally they said, of course, Lee was a separate person from the company he formed, and was held to get the compensation as he was a employee at the time of accident. Okay. Again, there are various other cases as well. We won't get into that, but there are many cases which, if you search, you will get lots of cases with respect to separate legal entity. So please do search. Next, limited liability. This we have already seen, I believe, but still, limited liability in the sense your liability is not unlimited. So in case of partnership, your liability is unlimited. I will give you an example. Let's say as a partner you have contributed 10 lakhs to your firm, and whereas other partners have also contributed 10 lakhs. Let's say 3 partners have contributed 10 lakh each, and in total 30 lakhs is the value of the capital of the firm. Now, due to some reason, the firm went into financial problems, and finally its debts came up to 35 lakhs. Now, as an individual partner, let's say A, can he claim, my capital is only 10 lakhs, I've already paid my capital, I'm not liable to pay anything more, so therefore please don't ask me any money? Of course not, because in case of partnership firm, your liability extends beyond your paid capital. Whatever capital you may or may not have paid, it goes beyond that. So we cannot say my liability is only that much. So that is something which you have to keep in mind. Members, even as a whole, are neither the owners of the company's undertakings nor liable for its debts. That we already seen. In other words, a shareholder is liable to pay the balance, if any, due on the shares held by him. Okay. So that means sometimes what happens, you might not have paid full amount on your shares. For instance, 10 rupees might be the face value, and 5 rupees might be the called up capital. Remaining 5 has not been called up, or it has been called up but you have not paid up. So now you hold, let's say, 1000 shares. How much is due from you now? The 5 rupees which you have not paid. So that is 5000 shares or rupees. Now if the company by chance goes into liquidation, they can only ask you to pay the remaining 5000, which is nothing but the unpaid capital amount. That's it. They cannot ask anything beyond this. So that is exactly what we mean by limited liability. So the liability is limited to the extent of money which you have not paid on account of the capital which you hold. Then what else? Okay, one of the important concepts is which is enumerated in this case law as well. Please do read it. It's pretty obvious. Perpetual succession. This is interesting. So if in a proprietary concern, if the proprietor dies, the concern will also die with the proprietor. In a partnership also, the same thing will happen. If even if one of the partners die, the partnership firm's existence will change. The number of partners will be different now. A new partner may or may not come, etc. All those things will happen. Whereas in case of a company, even if all the members of the company die, the company will still have a life of its own. Only because how was the company incorporated? Through law. It's not a natural process, of course. So now again, through law only, the company will be wound up. So there is no way uh, the company will die a natural death. So it has to follow a due process. After the due process has been followed, and if the ROC, that is the registrar of companies, which is gone with the duties of taking care of the company affairs on behalf of the Ministry of Corporate Affairs, if they are satisfied with the process of winding up, then they will say this company has been wound up. Otherwise, the company will be in existence. Okay, there is this famous line: members may come and go, but the company can go on forever. Okay, so that is the thing. Separate property, we have seen it can own separate property in its own name. Transferability of shares, this is one of the important features of a company. You cannot transfer your shares in a partnership firm. You cannot say, I have been the partner since some time now, I want to transfer my shares to someone else and they will become the partner henceforth. No, the other partner's permission will be required first of all, because unless they agree, they cannot you cannot do that. Whereas in case of a company, especially if it's a public limited company, so you can freely transfer the shares. Let's say you hold 100 shares of some company and you do not want to be um, owning those 100 shares of the company anymore. So what can you do? You can simply transfer those shares to someone else through share market or elsewhere. So that is something which a company gives freedom for. Of course, with respect to private limited companies, it might still be difficult. Of course, you will get not that difficult, but still it is far more easier when it comes to a public limited company. Capacity to sue and be sued, it is more like registered partnership firms. Won't get into that. Contractual rights, again, since a company has a separate legal entity, it can enter into contracts and enforce contracts, and someone else can also enforce contract on the company because it is a separate entity. Limitation of action, this is interesting. A company cannot go beyond the power stated in the memorandum of association. See, this memorandum of association is like a constitution for the company. Whatever the company wants to do, it will be mentioned in memorandum of association, like the objectives. So initially, when the company is being incorporated, you will have to decide and mention the objectives of the company. Of course, you cannot mention 100 different objectives in 100 different areas. It should be in one particular area. And if there are any collateral objectives, that is also fine. But if it's something totally unrelated, um, most likely you will not get the certificate of incorporation. Anyway, so the point here is you cannot go beyond what is stated in a memorandum of association. So that's it. So if at all you want to do something and which goes against or beyond a memorandum of association, then you will have to make sure that that is first altered and then you can go beyond that. Separate management, that we already seen. Voluntary association of profit, again, it's a voluntary association, no one is forcing you. So but, and also we should consider that it's a association for profit, not association not for profit. Termination of existence, we already seen, it cannot die a natural death, it has to be wound up through due process only. Nationality and residence of a company. Okay, let me just check how many more pages are there. Okay, quite a few. Let me take a break of couple of minutes and then we'll continue. Welcome back. Let's continue. Nationality and residence of a company. Uh, let's see. Though it is established through judicial decisions that a company cannot be a citizen, yet it has nationality, domicile, and residence. Okay. Let's see what exactly in this case Gask versus Inland Revenue Commissioners 1940 Kings Bureau, I guess, KB. McNacton J held that a limited company is capable of having a domicile, and its domicile is the place of its registration, and domicile clings to it throughout its existence. Okay. In another case, they say joint stock company resides where its place of incorporation is, where the meetings of the whole company or those who represent it are held, where its governing body meets in bodily presence for the purpose of the company and exercises the powers conferred by it and by articles of association. Articles of association is slightly inferior to memorandum. If memorandum talks about the broad uh, strokes, articles of association is looking at the finer aspects like the rules, internal management, all those things. The company, though a legal person, is not a citizen under the Citizenship Act of 1955 or the Constitution of India. Okay, that is something which we should keep in mind. Concept of corporate personality, we have already seen this again. Okay, anyway, let's see. Lifting or piercing through the corporate veil. We know it has a distinct personality. So when can we lift that corporate veil and actually see who exactly is in charge of the company? Sometimes we may have to do, sometimes we may not be able to give that benefit of separate legal entity for few reasons. Let's see what are those cases. Mm, where a fraudulent and dishonest use is made of legal entity. Fraudulent and dishonest, something which you should not have done, but the company did it just to take advantage of its separate legal entity. So, in such a case, we'll break through that sham of corporate veil or separate identity and see who exactly is in charge of the decisions, and then we may have to punish those who violated that. Okay. The corporate veil is lifted when in defense proceedings, such as evasion of tax, an entity relies on its corporate personality as a shield to cover its wrongdoings. This is interesting. Sometimes, if uh, the company evades tax payment or does involve itself in any wrongdoing, then we'll have to pierce the veil or lift the veil to check who exactly did this. Mm. Okay, let us look at the situations. The courts have found it necessary to disregard the separate personality of a company in the following situations. Which are those? Where the corporate veil has been used for commission or fraud or improper conduct. If you do indulge in such situations, court will lift the veil. Where a corporate facade is really only an agency instrumentality, meaning you are you have incorporated a company only to act as your agent and nothing else. Otherwise, it is completely your decisions. You are not giving respect to that separate legal entity. In such cases, also they will lift the veil. Where the doctrine conflicts with the public policy, courts lift the corporate veil for protecting the public policy. So if it goes against public policy in such a circumstance, also the court will lift it. They say, if it is deemed that the company has an enemy character, how do we know if it's enemy character? It's very simple. The persons who are actually managing the company, if they are residents in enemy country, for example, if all the board of directors is this management body which governs the company. The company, as we already know, cannot think on its own. Someone has to drive the company, no? So we have board of directors who are, let's say, the people who actually are the brains of the company. So if those brains are residents of enemy country, then the company will also naturally have the character of enemy. So in such cases, we'll lift the veil. We will not say it's a separate legal entity. where it is found that the sole purpose for which the company was formed was to evade taxes. We already seen. Avoidance of welfare legislation is common as avoidance of taxation. If you want to avoid welfare legislation and create a company just to do that, then also it will be lifted. Okay, there are other reasons, not very important. Okay. Distinction between company and partnership. Okay. A company is a distinct legal person, whereas partnership is not. In partnership, the property of the firm is the property of the individuals comprising it. In company, it belongs to the company and not the individuals comprising it. Creditors in a firm, creditors of the firm are creditors of individual partners, and decree against the firm can be executed against partners jointly or severally. Whereas creditors of a company can proceed only against the company. That is very interesting. If you are a creditor with respect to a partnership firm, you can proceed against one of the partners, ignoring the other partners. So that is there. Whereas in case of company, you can't do that. A partner cannot contract with his own firm, whereas a member of a company can. That is interesting. So because a partner is not distinct from the partnership firm, whereas a member is distinct from the company. So separate legal entity concept will come into picture here. A partner cannot transfer his share. We already seen. Restrictions on partners' authority contained in the partnership contract do not bind outsiders. If there is anything in the partnership firm, or rather the deed, we will not be bound by that. Outsiders will not be bound by that. Whereas in case of incorporated company, if there is nothing anything mentioned in the articles, then we will also be bound by that, because we are bound to acquaint ourselves with such rules and memorandum as well. So that is something which is unique here. Why so? Because if you are dealing with the company, you should know what the company is capable of dealing with. Maybe the company doesn't have that particular thing as its objective at all. So then whatever the company has been doing would be illegal. So you have to be careful here. A company has perpetual succession. We all seen that partnership firm will not have, obviously. A partner's liability is always unlimited. Seen. Company is legally required to have its accounts. Oh, this is interesting. In case of company, you have to have your accounts audited through a practicing chartered accountant. Whereas in case of firms, you can get it audited through anyone whom the audit partners feel are capable. It could be a non-chartered accountant as well. A company being a creation of law can only be dissolved. We already seen, so no need to go there. Distinction between company and joint Hindu family business, not very important. Just to go through, it is fairly obvious. Again, distinction between company and LLP. Here there are less number of distinctions compared to company and firm, because LLP by nature has limited liability. So you cannot say there is unlimited liability here. Okay. Disadvantages of corporate form of enterprise. What are the disadvantages? We have seen the advantages so far. Formalities and expenses. Since it is a corporate form of enterprise, since there is a system, there will be lots of formalities as well. There will be lots of expenses as well. So those things will be there. You just can't escape such things. Corporate disclosures. Since you are a company now, disclose whatever is required to be disclosed, because now you belong to the public. Especially if you are a public company, you come under public domain, so you have to make sure that you disclose sufficiently whatever is to be disclosed. Separation of control from ownership. Ownership is not the same as control. You may have the maximum number of shares, but you may not be controlling the company. Who controls the company? As I said, the minds of the company, basically the board of directors, they control the company. Greater social responsibility. If yours is a company, then you not only are responsible towards your employees, but also are responsible towards environment around you and your factory. Greater tax burden in certain cases. In fact, in almost all the cases. Income tax rate, for instance, would also be very high if you are a company as opposed to an individual. Detailed winding up procedure. Winding up process is not so easy. We may say ease of business and all that, but when it comes to winding up, it's difficult in the sense it's a long winding process. That's all. Not difficult. There are people who can do that for you, like company secretaries, but it's a long winding process. So again, the same thing is mentioned here. I don't want to get into that again. Oh, journey of Indian company law. This is interesting. Mm. So in England, it was enacted in 1844. They say. Mm. Okay, in India, it was passed in 1850. Oh, okay, much before 1956 Act. Mm. Not very important. All these are just history. Mm. Again, various Companies Acts were enacted between 1850 and 1951. So then the government of India thought it fit to come out with a new act. So then we came out with Companies Act of 1956. Okay. So that 1956 Act contains 658 sections and 15 schedules. This is very interesting. The Act is the longest piece of legislation ever passed by our Parliament. So that is fine. You may get that as a question. Be careful. Next. So major changes were there. So but afterwards, so then people thought it fit to get a new act instead of keeping the old one and changing it frequently. So that's when many committees, in fact, suggested to have a new Companies Act, and it was suggested in 2004 only. No, hmm? They said report charting out the roadmap for a flexible, dynamic, and a user-friendly new company law. So it took 10 years to get that. Anyway, that's a different thing. So Companies Bill of 2012 came into picture. Then Companies Act of 2013 came into picture. So yeah. Okay, what about the applicability of Companies Act? According to Section 1 of the Companies Act extends to whole of India. Okay, so and it will be applying. It will apply to following: who companies incorporated under this act means this act, or any previous act, previous 1956 or much earlier. So if your company was incorporated way back in time, so even then it will still be a company, and it will also come under Companies Act of 2013. We cannot say my company was incorporated earlier to this act, so therefore this act is not applicable. No, retrospective effect. Insurance companies, except in so far as the said provisions are inconsistent with the provisions of the Insurance Act or the Insurance Regulatory and Development Authority Act of 1999. Meaning, most of the insurance companies will come under Companies Act only, but there may be certain provisions, especially with respect to the financial statements, etc., wherein Insurance Companies Act, or rather Insurance Act of 1938 or this IRDA of 1999 will be applicable. Same thing with banking companies. They are also companies. No? For example, SBI Limited, HDFC Limited, they are all companies. Companies Act's provisions will prevail there too, except when it is going against the or except when it is inconsistent with the provisions of Banking Regulation Act. When it is inconsistent with the provisions of Banking Regulation Act, or if there are contrary views with respect to one issue in Companies Act and Banking Regulation Act, then the Banking Regulation Act will prevail. Same thing with electricity companies as well. Okay. Okay, now let us look at types of companies. We have private companies, public companies, and one person company. This again was not there in 1956 Act, and even in 2013 when the Act was enacted, it was not introduced. Now it has been introduced. So let us see. Other forms of companies are also there, like companies with charitable objects, Section 8 companies, Section, yeah, government companies, foreign company, holding and subsidiary company, associate company, joint venture, investment company, producer company, non-banking financial company. Okay, let's see. Private company. This is the most popular form of companies, wherein we say the rights and right to transfer the shares is restricted. As I said, it's not so easy as in case of public company, but still it can be transferred with the permission of the company. So in case of private limited company, you just need 2 members, minimum 2, maximum would be 200. Whereas in case of one person company, so it also comes under private limited company only, you need only one member. So one of the other characteristics of private company is it prohibits any invitation to the public, meaning you cannot invite public to subscribe to the shares of your company. So that is one thing, because it's a private limited company, closely held company. Public company means a company which is not a private company. So very simple definition. So meaning, if it's not a private limited company, then by default it becomes a public limited company, and it has a minimum paid up share capital as may be prescribed. Okay, very simple definition. One person company, we know, has only one person as member. Okay, so the only requirement here is you will have to appoint some nominee in case something happens to you, or if you die, someone else should be able to take care of that. So that is there. Now, companies with charitable objects. A person or an association of persons registered and licensed under Section 8 of the Companies Act has a limited company. Okay, as I said, Section 8 companies. I think earlier it was Section 25 in Companies Act of 2013. The same thing has been written in different form. That's all. So, what is the main objective here? Not for profit, to serve the society. So it will apply all its profits, or if at all they have profits, so other income, in promoting its objects, not to distribute money as dividend. Intends to prohibit the payment of any dividend to its members. As I just now said, it cannot pay the dividend to its members, because the whole idea behind Section 8 companies is not for profit, to serve. You get money maybe from your members or donations, whatever, and you just spend that money for various purposes of the company. Government company, as the name itself says, company which is majorly held by governments. Like it could be one government, maybe central government holds more than 50 or 51% or more. Maybe a state government holds 51% or more. Maybe a combination of central and state, or maybe a combination of state and state. So both put together, it is more than 51%. In all these cases, we say it's a government company. Foreign company. Foreign company, again, incorporated outside India. So it has a place of business in India, and conducts any business activity in India in any other manner. Associate company has a significant influence, but which is not a subsidiary company. Okay. So significant influence means control of at least 20% of the total voting power. So when do we say it's a subsidiary company? When it is holding majority shares. Majority means more than 50%, at least 51% of the shares. So there is again the holding company. If you hold 51% of the shares or more than that of any other company, you will be considered holding company, and that other company whose shares you are holding will be considered as subsidiary. Small company, again important from the point of view of exam, which does not exceed 50 lakh. The paid up capital should not exceed 50 lakh or such higher amount as may be prescribed. But whatever higher amount should not exceed more than 10 crores. And the turnover or the revenue of which, as per the latest P&L, should not exceed how much? 2 crore rupees. So there are two concurrent conditions. Paid up capital should not be beyond 50 lakhs, plus the turnover should not have exceeded 2 crores. So that is the thing. Dormant company, again a company which is not active. Where a company is formed and registered for a future project, or to hold an asset or intellectual property and has no significant accounting transaction, such a company is known as dormant company, inactive company. So All this, the rest you can easily understand. Let me just quickly see how much is left. Yeah. Formation of a company. According to Companies Act 2013, a company may be formed for any lawful purpose by 7 or more persons. This is of course public limited. Minimum 7 in case of public, maximum no limit. Okay. 2 or more persons in case of a private. 1 person in case of a 1 person company. A company may be limited by shares, limited by guarantee, or an unlimited company. No one wants to start an unlimited company, believe me, because that is the whole point of starting a company. So why would I want to start an unlimited company? I might as well start a partnership firm. Okay. Limited by shares means whatever amount is due towards your shares, you will pay only that much. Limited by guarantee means you will guarantee X amount in case of liquidation, so that beyond the shares which you own. So in that case, it will be company limited by guarantee. So incorporation of a company, let's see. An application for registration of a company shall be filed with the ROC. So in form number so and so. See, all these things you can just memorize along with the prescribed fee. So the memorandum and articles of the company duly signed by all subscribers. So at the time of incorporation only, your M&A should be ready, memorandum and articles. So signed by all the subscribers. Declaration in the prescribed form by a company secretary or a chartered accountant or a cost accountant or an advocate who is engaged in the formation of a company, and by one declaration by such a person, a professional basically, and other by someone named in the articles as director, manager or secretary of the company, saying that whatever requirements are there in the act for registration or incorporation of the company, they have been complied with. So that is the declaration. Declaration again, in the articles, that the person who is actually signing is not convicted of any offense in connection with the promotion, formation or management of any company. That means you have not done any wrongdoing with respect to incorporation of a company or company as such. So earlier, so what is the set off period here? So preceding 5 years, you should not be convicted in the last 5 years from the date of applying for registration of this company. Address for correspondence till its registered office, okay, is established. Okay, that also should be mentioned. Particulars of name, including surname or family name, residential address, etc., 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 of every subscriber. Excuse me. Particulars of persons mentioned in the articles as the first directors of the company, that shall also be mentioned. What else? Yeah. Again, other formalities needs to be followed. Then we have the share capital. The term capital has a variety of meanings. It may mean one thing to an economist, another to an accountant, while another to a businessman or lawyer. Okay. A layman views capital as the money which a company has raised by issue of its shares. That is true. Whatever the money the company has raised by issue of its shares, it is known as capital. It uses this money to meet its requirements by way of acquiring business premises and stock in trade, which are called the fixed capital and the circulating capital respectively. Okay. So what they are trying to say is, you start your company with the capital amount invested by the owners or the shareholders, and with that you start your business, purchasing various things which are required for office use as well as for trading. So share is a share in the share capital of the company. If this is the share capital, this particular portion only represents a share in the share capital of the company. Again, in share capital also we have certain classification. One is of course nominal or authorized or registered capital. That means the maximum capital which a company can raise. What is that maximum capital? Let's say 10 crores. If that is the thing, you cannot go beyond this. That's it. And out of the 10 crores, how much have you actually issued to the shareholders? So that will become the issued capital. Then out of that issued capital, how much has been subscribed by the shareholders? Have they subscribed to everything? Okay, then it becomes 10 crore. Then there is called up. This again is not very relevant these days, because usually the companies get the money in one shot itself. Earlier it used to be like installments, let's say of 3 rupees during application, 2 during first call, and rest during final call. Final call has not been called up, so then only 5 rupees, that is 3 plus 2, will be the called up amount. Paid up means out of whatever you have called upon the shareholders, how much have they paid? Have they paid enter 5, then that will become the paid up as well. Equity share capital. Okay, two different types of shares. One is equity share, another is preference share. Let's look at preference share. That way it will be easy to understand what is not preference share is equity share. Preference share means, as the name itself says, they will get preference over equity. That's all. When it comes to liquidation. So if at all company has to wind up, it has to pay back the money which it has received from various people. So it has to pay back the money to the shareholders as well. But first it will make the payment to the preference shareholders. Then if there is anything left, then it will make the payment to the equity shareholders. Likewise, in case of payment of dividend also, the same thing is done. First you make the payment of dividend to the preference shareholders. Then if there is anything left, you make the payment to the equity shareholders. Board of directors. This we have already seen. Section 152 of the Act provides that where there is no provision made in Articles of Association of the company for appointment of the first directors, then, if nothing has been mentioned there, then the subscribers to the memorandum who are individuals shall be deemed to the first directors. Nothing is mentioned in the board articles, then whoever subscribed to the shares, according to the articles, they themselves will be considered as directors. Every director shall be appointed by the company in the general meeting, that is the annual general meeting. So, but one technical thing is, first of all, they should be allotted director identification number, DIN. So only then they will be made the directors. Every person proposed to be appointed as a director by the company in general meeting or otherwise shall furnish his director identification number or such other number as may. Okay, that is fine. Okay. So what exactly happens to the directors? How are they appointed? Unless the articles provides for the retirement of all directors at every annual general meeting, not less than 2/3 of the total number of directors of a public company shall be persons whose period of office is liable to determination by retirement of directors by rotation, save as otherwise expressly provided in the Act, be appointed by the company in general meeting. Meaning, so if nothing is mentioned, at least 2/3 of the directors are liable to retirement, whose period of office is liable to termination by retirement of directors. Meaning, so your office will be terminated. How? By this concept of rotation. Meaning, I will retire now, maybe you will retire next year, but minimum how much? 2/3. So again, you will be appointed in the same meeting as well. Same in the sense, general meeting only. Okay. Because once the 2/3 retire, someone else has to fill their place, no? So others will be appointed. Then those 2/3 will retire. Then again someone else will be appointed. Usually it's a rotation. It's not like every time they appoint fresh faces. At the first annual general meeting of the public company held next after the date of general meeting, at which the first director is appointed. This is what I don't like. They use such complex long language just to confuse you. That's all. It's not that difficult. Okay, let's see. To make it sound simple, but institute being institute. At the first annual general meeting of a public company held next after the date of general meeting, at which the first directors are appointed in accordance with the clauses A and B, and at every subsequent AGM, 1/3 of such directors for the time being as are eligible to retire by rotation, or if their number is neither 3 nor a multiple of 3, then the number nearest to 1/3 shall retire from office. How exactly it happens? This is what they have said. So, because I said 2/3 and 1/3, no? So what if it is not mathematically not possible? Then round it off, basically, that's all. So now who will retire? Those who have been longest in office since their appointment, they will retire. So this is what I said earlier. At the annual general meeting at which the director retires as aforesaid, the company may fill up the vacancy by appointing the retiring director himself or herself. So he retired because of the rotation policy. Then again they are being appointed. So that is also there. Then we have removal of directors. So you can remove them as well due to various reasons. Then there is meetings of board. So since, as I said, board is the the brains behind the organization. So the board has to meet and work efficiently, otherwise the company will not be run properly. So the Companies Act says the first board meeting should be held within how many days? 30 days of the date of incorporation. Wherever dates are mentioned, please do mark it so that it will be easy for you to revise. So your attention will be captured immediately when you mark that in your book. In case of one person company, you will conduct one meeting in each half of the calendar year. So that is very important. There shall be minimum of 4 board meetings every year and not more. What is this exactly? 4 board meetings is fine for other companies, not other than one person. And not more than 120 days shall be intervene between 2 consecutive board meetings. That means the gap between consecutive meetings, successive meetings, should not be more than 120 days, or roughly speaking 3 months. 4 months. No? Yeah. Directors may participate in the meeting either in person or through video conferencing or other audiovisual means. Okay, that is fine. So what is the quorum for the meeting? 1/3 of the total strength or 2 directors, whichever is higher. If there are, let's say, 6 directors, so 1/3 of that will still be 2 directors. If there are 9 directors, 1/3 of that will be 3 directors, whichever is higher. Okay, either 2 or whichever is higher. Then there is shareholders meetings as well. So how do we meet? Annual general meeting. As the name itself says, it's annual, so it is held once in a year. Convening of one such meeting every year is compulsory. It should be held once in each calendar year. Subsequent annual general meeting of the company should be held within 6 months from the date of closing of the relevant financial year. Meaning, if my relevant financial year closes on March 31st, 6 months from that, so that would be September 30th. Before that, you should hold the AGM. And at least once in calendar year. And the gap between 2 AGMs should not be more than 15 months. Again, very important from the point of view of exam. So they are given business hours also. Between 9 and 6 p.m. you can hold, not before that, not after 6 p.m. And that day, which is not a national holiday. And it should be held either at the registered office of the company or at some place in which the registered office of the company is situated. So either you can hold it in office itself, or maybe some other place where your registered office is also located in the same city. Maybe you want to hold it in some kind of hotel or somewhere, who knows. What are the things which you do in case of annual general meeting? What are the main businesses? So first of all, consideration of financial statements, or rather adoption of accounts. So that is the first thing which you do. Then declaration of dividend. Then appointment of directors. Then we have appointment and fixing of remuneration of auditors. So remember this. So these are the 4 things: A, D, D, A. Okay, adoption of accounts, declaration of dividend, then appointment of directors, and appointment and fixing the remuneration of auditors. All these things will happen in case of a shareholders meeting. Then this new thing is their corporate social responsibility. So every company having a net worth of rupees 500 crores or more, or turnover of rupees 1000 crore or more, or a net profit of rupees 5 crore or more, in all these cases it will be immediately, it will be applicable. What will be applicable? CSR. So you'll have to make sure there is CSR board, committee um, consisting of 3 or more directors, out of which at least one director shall be independent director. Okay. So they will formulate and recommend all the activities or policies as to how the company should spend money towards its corporate social responsibility. So again, penal provisions are there as to what will be the punishable, what will be the amount which will be levied in case the company doesn't fulfill or rather follow the CSR practice. So where all can you invest when it comes to CSR? So there are different activities in which a company can invest money to promote corporate social responsibility. It's not restricted to any one field, so you can do whichever you feel is ideal as a company. So then there is business ethics. I won't get into this, it's more like moral science, so please do read that once, not very important. Yeah, that's all about this. Let me also mention that now this was a crash course. Obviously we couldn't have covered everything in limited time. This is more like something which can refresh your memory. I am assuming that you have already studied this, and this is nothing but just going through the syllabus, touching upon things here and there, because with this much amount of time, that is all we can do. But if you are interested in knowing more about all these things in detail, I would suggest please do check out our website. So it's the link for which is in the description. Register there. You'll get detailed, what is that, chapter wise lessons already recorded, so you can definitely watch and get the benefit of that. Not only that, you can also take up daily quizzes, MCQs, etc. You will get notes as well, so do that. And all the best for the exam. So one last thing is left, that is the current affairs, which I will take it up in the next class, most likely on Monday. Thank you.